All right, people. So welcome to Jumbo IAS and welcome to UPSC Prelims Phoenix batch. In this batch, we revise the entire syllabus for UPSC Prelims examination, both static as well as current affairs. Now, this particular lecture is related to our static lecture series. And in that static lecture series, you already know this by now, we are covering Indian polity. And today is day 3 of Indian polity, and your daily targets for today were fundamental rights, all fundamental rights. So we are going to revise the chapter on fundamental rights through a set of 30 MCQs. But the notes for those fundamental rights from which these questions would come, well, they were already shared with you, and I'm hoping that you have already gone through those notes. Only then you should sit for this lecture. First revise the notes and then revise them again through a set of 30 MCQs through this lecture. All right. So this is the purpose of this lecture. Now let's straight away dive into the lecture. Let's straight away start our discussion. Okay. So Indian polity day 3, and well, our targets were fundamental rights. Okay. So let's start with question number 1. So consider the following statements regarding the nature of fundamental rights. Fundamental rights are absolute and cannot be restricted by state under any circumstances. The most fundamental rights are self-executing, but some require parliamentary legislation for their enforcement. Only the parliament is empowered to make laws for giving effect to fundamental rights to maintain uniformity across the country. Now, first statement is absolutely incorrect because obviously you must have heard about reasonable restrictions. Yes, there are fundamental rights, and fundamental rights puts a check or limits state power. But there are reasonable restrictions to these fundamental rights as mentioned in different articles. So they are not absolute. So first statement is false. Now, some fundamental rights are self-executory, okay? They are there. But for some fundamental rights, well, you need to enact a law to enforce them. So for example, Article 19, Clause 1, Subclause A, freedom of speech and expression. It's self-executory. Everyone has freedom of speech and expression, okay? But so there is no parliamentary law required to execute this. But let's suppose there is Article 17, which is abolition of untouchability. Now, Article 17 says that untouchability shall not be practiced. But if there is any person who practices untouchability, he or she shall be punished by law. Okay. So to abolish untouchability, Parliament has to enact a law. How to abolish untouchability? Who would be punished? What are the crimes that are punishable? For that, you need a law. So Article 17 is not self-executory. Okay. So this statement is correct. Some require parliamentary legislation. But remember, laws can be made by Parliament as well as state legislative assemblies. For enforcement of fundamental rights, only Parliament is entitled to make a law. Okay, so this is also correct. The correct answer would come out to be D. Okay, next. With reference to Article 12 of the Constitution, which of the following are included in the definition of state? So you see, the chapter on fundamental rights starts from Article 12. Okay, and ends at Article 35. Now, Article 13 clearly says that state cannot take away your fundamental rights. Now, the question is, what is a state? Is Parliament state, or Prime Minister is also part of that state, or courts are also part of that state? You need a proper definition of state, okay? Because these fundamental rights are available against the actions of state. So what is a state? Are PSUs included in state or not? So a proper definition of state was given in Article 12. Okay. Now, what is included in the definition of state? Panchayats and municipalities, yes, they are also part of state and they cannot take away your rights. Private bodies working as an instrument of state. Sometimes government hires private bodies to do a certain task. Those private bodies are also part of this definition of state. Judiciary, yes. Housing boards, well, Article 12 clearly says that housing boards are not part of the definition of state. So the limits put by fundamental rights do not extend up to housing boards. So this is false. The answer would come out to be 1, 2, and 3, again B. Okay, remember this part, housing boards, because it is a confusing thing. So they might ask an MCQ related to that, a similar MCQ. Okay, question number 3. Consider the following pairs regarding constitutional doctrines. Doctrine of eclipse applies primarily to pre-constitutional laws that clash with fundamental rights. Doctrine of severability allows a law to remain enforceable by removing only the unconstitutional provisions. Doctrine of basic structure, which most of you are aware of, established that Parliament cannot amend fundamental rights if it alters the core of the Constitution. So this doctrine of basic structure is absolutely correct. Now let's talk about doctrine of eclipse. You see, no law can violate fundamental rights. This is mentioned in Article 13 clearly. Okay, but there are certain pre-constitutional laws, okay, which were enacted during British time, and they are currently going on. Now, if those laws are violative of fundamental rights, then what will happen? Well, if there are any pre-constitutional laws that are violative of fundamental rights, then what will happen? Well, those laws won't be cancelled. They would be unenforceable. So the law would exist, but it won't be implemented because it violates fundamental rights. As soon as you amend those fundamental rights which were violated by this law. So let's suppose there was a law that violated Article 25. Now, as soon as you amend Article 25, sometime in future, like 50, 60 years later, you amend Article 25 so that this law is not violative of fundamental rights anymore. Then this law would become alive again. So this law was not cancelled. It was just hidden, eclipsed. Okay, this is there. Then doctrine of severability says that let's suppose there is a law which has 4 parts, A, B, C, D. Let's suppose part B is violative of fundamental rights. Okay, so anyone would say that this law is violative of fundamental rights. Now the courts have said that if only a particular portion is violative of fundamental rights, only that portion will be cancelled. All the other 3 portions would be executed. This means that we'll cut that portion of the law, sever that portion of the law that is violated. Okay, and the others would continue. This is doctrine of severability. Allows a law to remain enforceable by removing only the unconstitutional portions, like B over here. So this is also correct. All 3 definitions are correct. All right. Next. Regarding the suspension of fundamental rights during a national emergency, which statement is correct? All fundamental rights are automatically suspended. Article 19 can be suspended only on grounds of external aggression or war. Article 20 and 21 can be suspended during martial law. Suspension of rights can only be done through constitutional amendment acts. Now, when there is a national emergency, Article 352. Article 358 says that as soon as there is national emergency, Article 19 will get automatically cancelled. But all the other rights won't get automatically cancelled. If you want to suspend all the other fundamental rights, there is Article 359, which says that President, by a proclamation or by an order, presidential order, can suspend any other fundamental right, which those fundamental rights would be written in that presidential order. Okay, so President can do it, but they are not automatically suspended. Okay, only Article 19 is automatically suspended. So first statement is false. Okay, then in 44th Constitutional Amendment Act, it was added that Article 19 will only get automatically suspended if the national emergency is because of war or external aggression. Okay, not because of any armed rebellion in the country. Only war and external aggression. Okay, so well, second statement is absolutely correct. Only on grounds of external aggression or war. In 44th Amendment, it was also added that yes, President can suspend through a presidential order all the other fundamental rights except Article 20 and 21. Article 20 and 21 will never get suspended. Article 21 is right to life. Article 20 is protection against offenses. Okay, no ipso facto law, double jeopardy. Okay, all these things. So these two would never get suspended. So this is false. And this is not true. Suspension can happen through presidential orders. So the correct answer would be B. Okay. Next. The intelligible differentia test, often used by judiciary, is associated with which article? Okay. Now look, Article 14 says that there shall be right to equality. And Article 14 actually reads equality before law. okay, and equal protection of laws. Now, equal protection of law means that equals to be treated equally, unequals unequally, which means that if there is a section of society that is already is at a disadvantageous position, then state can discriminate in favor of that community to uplift it. So state can basically do that to uplift it. Okay, so this can happen. Clear? Now, which community will the state discriminate in favor of to uplift that? Well, for that, the courts will look at intelligible differentia. Okay, intelligible differentia is how have you classified that community? How have you proved that this action that you're taking will bring them up? This is intelligible differentia test, which is in favor of, which is for Article 14A. Okay, next. Consider the following statements regarding Article 15. Discrimination is prohibited on grounds only of religion, race, caste, sex, place of birth, or language. The state is empowered to make special provisions for economically weaker sections to a maximum limit of 10%. Special provisions for EWS can be made in private unaided educational institutions. Now, which are correct? So, discrimination is prohibited on grounds only of religion, race, caste, place of birth, not language. Okay, language is not there in this, so this is false. State is empowered to make EWS reservation, yes. Special provisions for EWS can be made in private unaided educational institutions, yes. Okay, so the answer would come out to be B. Okay, next. In the context of Article 16, that is reservation with respect to public employment, what does the carry forward rule refers to? So carry forward rule is, let's suppose there is 49% reservation for reserved categories, okay, and 51%, okay, and 51% for general category. Let's suppose in some administration, some posts, there were 100 posts that were advertised. So 51 posts would go to general and 49 would go to reserved. Yes, but let's suppose only 9 seats got filled and 40 remained vacant. No reserved category came. Next year, again 100 seats were advertised. Okay. Now the thing is, next year 100 seats are required, but these 40 would be carry forwarded. So 140 seats would be advertised. Now, as per the rule, what should happen? Well, half of 140 is 70. 70 should go to general, 70 should go to reserve. But no, only 50 would go to general, and 50 plus 40, the unreserved, the vacant unreserved seats would be carry forwarded. No one would say that from this 140, well, 60-70% went to unreserved category. No one would say that. Why? Because this extra reservation is because previous years seats were unfilled. Okay, this is carry forward rule, treating unfilled reserved vacancy of a year as separate class to be filled in subsequent years. So B. Okay, next. Which of the following is our exceptions to equality before law under Article 14? Okay, there is equality before law, but there are certain exceptions. President of India is not answerable to any court for exercise of his official duties. No criminal proceedings can be instituted against a governor during his term of office. Foreign ambassadors enjoy immunity from civil and criminal proceedings. So everyone should be treated equally, but there are some exceptions like president, governor, some other constitutional posts, plus foreign ambassadors, foreign diplomats are protected under Geneva Convention. So they won't be treated equally. So these are some of the exceptions to Article 14. All are correct. Okay, next. With reference to abolition of untouchability, consider the following. The term untouchability is defined in Protection of Civil Rights Act 1955. Rights under Article 17 is available against both state and private individuals. Person convicted of an offense of untouchability is disqualified for the election of parliament. Okay, so the thing is that, remember I told you Article 17 is not self-executory. To execute it, Parliament had to enact a law. Parliament enacted a law, Protection of Civil Rights Act. Okay. Now, under this law, untouchability was not defined properly. Okay, it was not defined. The offenses were listed down and punishments were given, but formal definition of untouchability was not given. Okay, so this is false. Now, Article 17 is available against the state as well as private individuals. That means if the state is practicing untouchability, state shall be punished. If a private individual is practicing untouchability, they will also get punished. So this is correct. And as per Representation of People's Act 1951, any person who is convicted of untouchability shall not fight, sit, or shall not contest any elections. So this is true. So B. Right? Next. Article 18, Abolition of Titles. A citizen of India is prohibited from accepting any title from the state. So state shall not give any titles except military titles like colonel, general, all these, and academic titles like professor, doctor, this. Yes, any foreign state. The state, basically it means to say that no foreign state can give any titles to an Indian. So Indians cannot accept the title of sir, knighthood from British government or any other. This is also true. Private organizations or universities are not at all mentioned. So the answer is both A and B. This is expressly mentioned in Article 18. This was to ensure that there is equality of status. Earlier, before partition, before independence, there were these titles, zamindars, jagirdars. They created these social hierarchies, which violated the principle of equality of status. Okay, everyone is equal in the eyes of law. So for that, titles had been abolished. Okay, B.